Welcome to Supreme Court Opinions. In this episode, you'll hear the court's opinion in Lac du Flambeau, Band of Lake Superior Chippewa Indians v. Coughlin. In this case, the court considered this issue. Does the Bankruptcy Code unequivocally abrogate tribal sovereign immunity? The case was decided on June 15, 2023. The Supreme Court held that the Bankruptcy Code unequivocally abrogates the sovereign immunity of all governments, including federally recognized Indian tribes. Justice Ketanji Brown Jackson authored the majority opinion of the court. To abrogate sovereign immunity, Congress must make its intent to abrogate unmistakably clear in the language of the statute. The statute at issue here contains such unmistakably clear language. First, 11 U.S.C. Section 106, A expressly abrogates the sovereign immunity of governmental units for certain enumerated purposes. Section 101(27) defines governmental unit as United States, state, Commonwealth, district, territory, municipality, foreign state, department, agency or instrumentality of the United States, a state, a commonwealth, a district, a territory, a municipality, or a foreign state, or other foreign or domestic government. This definition exudes comprehensiveness from beginning to end, and other provisions of the Bankruptcy Code support this understanding as well. Federally recognized tribes are indisputably governments, so the Section 106A unequivocally abrogates their sovereign immunity. Justice Clarence Thomas authored an opinion concurring in the judgment. Justice Thomas reiterated an argument he has made before that to the extent that tribes possess sovereign immunity at all, that immunity does not extend to suits arising out of a tribe's commercial activities conducted beyond its territory. Justice Neil Gorsuch authored a dissenting opinion arguing that the court's clear statement rule requires the statute to expressly mention Indian tribes in order to abrogate their sovereign immunity. Because the Bankruptcy Code does not, he would hold that it does not abrogate federally recognized Indian tribes' sovereign immunity. The opinion is presented here in its entirety, but with citations omitted. If you appreciate this episode, please subscribe. Thank you. Justice Jackson delivered the opinion of the court. The Bankruptcy Code expressly abrogates the sovereign immunity of governmental units for specified purposes. The question presented in this case is whether that express abrogation extends to federally recognized Indian tribes. Under our precedents, we will not find an abrogation of tribal sovereign immunity unless Congress has conveyed its intent to abrogate in unequivocal terms. That is a high bar, but for the reasons explained below, we find it has been satisfied here. Petitioner Lac du Flambeau, Band of Lake Superior Chippewa Indians, the Band, is a federally recognized tribe that wholly owns several business entities. In 2019, one of the band's businesses, Lend Green, allowed respondent Brian Coughlin to borrow $1,100 in the form of a high-interest, short-term loan. But Coughlin filed for Chapter 13 bankruptcy before he fully repaid the loan. Under the Bankruptcy Code, Coughlin's filing of the bankruptcy petition triggered an automatic stay against further collection efforts by creditors, including Lend Green. Yet, according to Coughlin, Lend Green continued its efforts to collect on his debt, even after it was reminded of the pending bankruptcy petition. Coughlin alleges that Lend Green was so aggressive in its efforts to contact him and collect the money, that he suffered substantial emotional distress, and at one point even attempted to take his own life. Coughlin eventually filed a motion in bankruptcy court, seeking to have the stay enforced against Lend Green, its parent corporations, and the band, collectively petitioners. Coughlin also sought damages for emotional distress, along with costs and attorney's fees. Petitioners moved to dismiss. They argued that the bankruptcy court lacked subject matter jurisdiction over Coughlin's enforcement proceeding, as the band and its subsidiaries enjoyed tribal sovereign immunity from suit. The bankruptcy court agreed. It held that the suit had to be dismissed because the Bankruptcy Code did not clearly express Congress's intent to abrogate tribal sovereign immunity. In a divided opinion, the Court of Appeals for the First Circuit reversed, concluding that the Bankruptcy Code unequivocally strips tribes of their immunity. In so holding, the First Circuit deepened a split among the courts of appeals on this question. We granted certiorari to address the lower court's inconsistent holdings. Two provisions of the Bankruptcy Code lie at the crux of this case. The first abrogates the sovereign immunity of governmental units. It provides, notwithstanding an assertion of sovereign immunity is abrogated as to a governmental unit to the extent set forth in this section. It goes on to enumerate a list of code provisions to which the abrogation applies, including the provision governing automatic stays. The second relevant provision defines governmental unit for purposes of the code. It states that that term means United States, state, Commonwealth, district, territory, municipality, foreign state, department, agency or instrumentality of the United States, but not a United States trustee while serving as a trustee in a case under this title, a state, a commonwealth, a district, a territory, a municipality, or a foreign state, or other foreign or domestic government. The central question before us is whether the abrogation provision and the definition of governmental unit, taken together, unambiguously abrogate the sovereign immunity of federally recognized tribes. To abrogate sovereign immunity, Congress must make its intent unmistakably clear in the language of the statute. This well-settled rule applies to federally recognized tribes no less than other defendants with sovereign immunity. We have held that tribes possess the common law immunity from suit traditionally enjoyed by sovereign powers. Our cases have thus repeatedly emphasized that tribal sovereign immunity, absent a clear statement of congressional intent to the contrary, is the baseline position. This clear statement rule is a demanding standard. If there is a plausible interpretation of the statute that preserves sovereign immunity, Congress has not unambiguously expressed the requisite intent. The rule is not a magic words requirement, however. To abrogate sovereign immunity unambiguously, Congress need not state its intent in any particular way, nor need Congress make its clear statement in a single statutory section. The clear statement question is simply whether, upon applying traditional tools of statutory interpretation, Congress's abrogation of tribal sovereign immunity is clearly discernible from the statute itself. We conclude that the Bankruptcy Code unequivocally abrogates the sovereign immunity of any and every government that possesses the power to assert such immunity. Federally recognized tribes undeniably fit that description. Therefore, the Code's abrogation provision plainly applies to them as well. Several features of the provision's text and structure compel this conclusion. As an initial matter, the definition of governmental unit exudes comprehensiveness from beginning to end. Congress has rattled off a long list of governments that vary in geographic location, size, and nature. The provision then proceeds to capture subdivisions and components of every government within that list, and it concludes with a broad catch-all phrase, sweeping in other foreign or domestic governments. When faced with analogously structured provisions in other contexts, we have noted their all-encompassing scope. We find the strikingly broad scope of the definition of governmental unit to be significant in this context as well. The catch-all phrase Congress used is also notable in and of itself. Few phrases in the English language express all-inclusiveness more than the pairing of two extremes. For instance, if someone asks you to identify car manufacturers, foreign or domestic, your task is to name any and all manufacturers that come to mind, without particular regard to where exactly the cars are made or the location of the company's headquarters. Similarly, at the start of each Congress, a cadre of newly elected officials solemnly swear to support and defend the Constitution of the United States against all enemies, foreign and domestic. That oath, which each member of Congress who enacted the Bankruptcy Code took, indisputably pertains to enemies anywhere in the world. Accordingly, we find that, by coupling foreign and domestic together, and placing the pair at the end of an extensive list, Congress unmistakably intended to cover all governments in the definition, whatever their location, nature, or type. It is also significant that the abrogation of sovereign immunity in Section 106A plainly applies to all governmental units as defined. Congress did not cherry-pick certain governments from the capacious list, and only abrogate immunity with respect to those it had so selected. Nor did Congress suggest that, for purposes of Section 106A's abrogation of sovereign immunity, some types of government should be treated differently than others. Instead, Congress categorically abrogated the sovereign immunity of any governmental unit that might attempt to assert it. Other aspects of the Bankruptcy Code reinforce what Section 106A's and Section 10127E's plain text conveys. Through various provisions, the Bankruptcy Code offers debtors a fresh start by discharging and restructuring their debts in an orderly and centralized fashion. The automatic stay requirement, for example, keeps creditors from dismembering the estate while the bankruptcy case proceeds. The Code's discharge provision enjoins creditors from trying to collect debts that have been discharged in a bankruptcy case, and its plan confirmation provisions, as relevant here, bind each creditor to whatever repayment plan the bankruptcy court approves, whether or not the claim of such creditor is provided for by the plan, and whether or not such creditor has objected to, has accepted, or has rejected the plan. These protections sweep broadly, by their own terms. To facilitate the Code's orderly and centralized debt resolution process, these provisions' basic requirements generally apply to all creditors. Courts can also enforce these requirements against any kind of non-compliant creditor, whether or not the creditor is a governmental unit by virtue of Section 106A's abrogation of sovereign immunity. At the same time, so as to avoid impeding the functioning of governmental entities when they act as creditors, the Code contains a number of limited exceptions. For instance, the automatic stay requirement does not preclude governmental units from enforcing their police and regulatory powers in certain proceedings, or from pursuing specific tax-related activities. The Code additionally exempts from discharge certain debts for a fine, penalty, or forfeiture owed to a governmental unit. Reading the statute to carve out a subset of governments from the definition of governmental unit, as petitioner's view of the statute would require, risks upending the policy choices that the Code embodies in this regard. That is, despite the fact that the Code generally subjects all creditors, including governmental units, to certain overarching requirements, under petitioner's reading, some government creditors would be immune from key enforcement proceedings, while others would face penalties for their noncompliance. And while the Code is finely tuned to accommodate essential governmental functions, like tax administration and regulation, as a general matter, petitioners would have us find that certain governments are excluded from those provisions' reach, notwithstanding the fact that they engage in tax and regulatory activities too. There is no indication that Congress meant to categorically exclude certain governments from these provisions, enforcement mechanisms, and exceptions, let alone in such an anomalous manner. Our conclusion that all government creditors are subject to abrogation under Section 106A brings one remaining question to the fore: whether federally recognized tribes qualify as governments. Petitioners do not seriously dispute that federally recognized tribes are governments, and for good reason. Federally recognized tribes exercise uniquely governmental functions. They have power to make their own substantive law in internal matters, and to enforce that law in their own forums. They can also tax activities on the reservation. It is thus no surprise that Congress has repeatedly characterized tribes as governments, and this court has long recognized tribes' governmental status as well. We have done so generally, and also in the specific context of tribal sovereign immunity. Tribal sovereign immunity, we have explained, is a necessary corollary to Indian sovereignty and self-governance. Putting the pieces together, our analysis of the question whether the Code abrogates the sovereign immunity of federally recognized tribes is remarkably straightforward. The Code unequivocally abrogates the sovereign immunity of all governments, categorically. Tribes are indisputably governments. Therefore, Section 106A unmistakably abrogates their sovereign immunity too. Petitioners raise two main arguments in an attempt to sow doubt into these clear statutory provisions. Neither creates the ambiguity petitioners seek. For their opening salvo, petitioners try to make hay out of the simple fact that neither Section 10127 nor Section 106A mentions Indian tribes by name. Had Congress wanted to abrogate tribal sovereign immunity, petitioners claim, the most natural and obvious way to have expressed that intent would have been to reference Indian tribes specifically, rather than smuggle them into a broadly worded catch-all phrase. But, as explained at the outset, the clear statement rule is not a magic words requirement. Thus, Congress did not have to include a specific reference to federally recognized tribes in order to make clear that it intended for tribes to be covered by the abrogation provision. As long as Congress speaks unequivocally, it passes the clear statement test, regardless of whether it articulated its intent in the most straightforward way. Trying a different tack, petitioners point to historical practice. In statute after statute, they say, Congress has specifically mentioned Indian tribes when abrogating their sovereign immunity, and in no case has this court ever found an abrogation of tribal sovereign immunity where the statute did not reference Indian tribes explicitly. These statistics sound quite noteworthy at first glance, but they do not move the needle in this case. For one thing, none of petitioners' cited examples involved a statutory provision that was worded analogously to and structured like the ones at issue here. Moreover, the universe of cases in which we have addressed federal statutes abrogating tribal sovereign immunity is exceedingly slim. In any event, the fact that Congress has referenced tribes specifically in some statutes abrogating tribal sovereign immunity does not foreclose it from using different language to accomplish that same goal in other statutory contexts. Even petitioners appear to concede this basic point. They agree that Congress could have used a phrase like every government or any government with sovereign immunity to express unambiguously the requisite intent to abrogate the sovereign immunity of tribes. For the reasons discussed above, we believe Congress did just that. Petitioners further contend that even if the relevant provisions could theoretically cover tribes, the statute can plausibly be read in a way that preserves their immunity. According to petitioners, the catch-all phrase other foreign or domestic government might simply capture entities created through interstate compacts, which cannot neatly be characterized as a state or an instrumentality of a state under Section 10127E's enumerated list. Interpreted in that fashion, petitioners maintain, the catch-all phrase would exclude governmental entities that are not purely foreign or purely domestic, like tribes or the International Monetary Fund, IMF. If this interpretation of the statute sounds far-fetched, that is because it is. To find petitioners' construction plausible, we would have to interpret other foreign or domestic government to impose a rigid division between foreign governments on the one hand and domestic governments on the other, leaving out any governmental entity that may have both foreign and domestic characteristics, like tribes or the IMF. But Congress has expressly instructed that the word or, as used in the Code, is not exclusive. As a result, we have serious doubts that Congress meant for Section 10127 to elicit the laser focus on, or that petitioners' reading of foreign or domestic would entail. the dissent's own arguments undermine any suggestion that Congress adopted such a siloed view. For instance, the dissent repeatedly paints tribes as occupying a hybrid position between foreign and domestic, and posits that territories historically share this hybrid status as well, describing territories as tribes' close comparator. Yet, as the dissent readily acknowledges, Congress expressly included territories within Section 101(27)(z) definition of governmental unit. If, on the dissent's own account, territories are neither foreign nor domestic, and fall within Section 101(27)(e's purview nevertheless, it is hard to see how Section 101(27)(z) catch-all phrase would simultaneously exclude other entities that share that same feature. In any case, neither petitioners nor the dissent explain why the code would draw such a line in the sand. None of the carefully calibrated exceptions noted in Part 3(b) for governmental units performing regulatory and tax-related functions turn on whether a government is purely foreign or domestic. Likewise, it is hard to see why the code would subject purely foreign or domestic governments to enforcement proceedings, while at the same time immunizing government creditors that have both foreign and domestic attributes. Considering that the one thing every entity in Section 101(27)(z enumerated list has in common is its governmental nature, and that is the same characteristic that matters when the code addresses governmental units from one provision to the next, we are highly skeptical that Congress distinguished between governments in the way petitioners suggest. Undaunted, petitioners note that Congress has historically treated various types of governments differently for purposes of bankruptcy law. They assert that, in the decades leading up to the Bankruptcy Code's enactment, bankruptcy law afforded certain benefits to the United States or any state or any subdivision thereof, leaving out entities that did not fall into one of those enumerated categories. Even if petitioners' understanding of this history is correct, they have failed to demonstrate that the code carried forward any such differential treatment. Congress ushered in a new, unprecedented era in bankruptcy practice when it enacted the Code in 1978. Both Section 101(27)(e definition of governmental unit and Section 106(a)'s abrogation of sovereign immunity were some of the many changes Congress made. The prior statute did not provide a general definition for governmental entities, much less include any provision expressly abrogating government's sovereign immunity. Instead, it set forth a general definition for states, which encompass territories, possessions, and the District of Columbia. Then, in each provision where governmental entities were relevant, Congress specified the particular governmental entities to which that provision pertained. Section 101(27)(z definition of governmental unit has an undeniably broader reach than the statutory provisions that preceded it. Section 101(27)(z definition includes, for instance, foreign countries and instrumentalities, when such entities had generally been previously absent. And the expansive definition of governmental unit in Section 101(27) applies throughout the Bankruptcy Code. In addition, for those who find legislative history useful, the Senate and House reports that accompanied the Code indicate that governmental unit was intended to be defined in the broadest sense. When Congress later added Section 106(a)'s abrogation provision, it was that comprehensive definition of governmental unit that Congress used to specify the scope of the abrogation sweep. Thus, however Congress may have treated governmental entities in bankruptcy law prior to 1978, it had clearly altered its view about the scope of coverage relative to governments by the time it enacted Section 101(27) and Section 106(a). Those provisions unequivocally extend to all governments, for the reasons already discussed, and we decline to read ambiguity into the statute where none exists. We find that the First Circuit correctly concluded that the Bankruptcy Code unambiguously abrogates tribal sovereign immunity. Therefore, the decision below is affirmed. It is so ordered, Justice Thomas concurring in the judgment. As I have explained, to the extent that tribes possess sovereign immunity at all, that immunity does not extend to suits arising out of a tribe's commercial activities conducted beyond its territory, because respondent's stay enforcement motion arose from petitioners' off-reservation commercial conduct. Petitioners lack sovereign immunity regardless of the Bankruptcy Code's abrogation provision. I therefore concur in the Court's judgment. Tribal immunity is a judicial doctrine that is not mandated by the Constitution, developed almost by accident, was reiterated with little analysis, and does not reflect the realities of modern-day Indian tribes. To the extent that tribes have any sovereign immunity at all, it is a common law immunity. Unlike the sovereign immunity enjoyed by the states under the Constitution, common law immunity is not a freestanding right that applies of its own force when a sovereign faces suit in the courts of another. Rather, it normally depends on the second sovereign's law as a matter of comity. Because no federal law accords tribes sovereign immunity in federal court, petitioners lack immunity in this federal case. Moreover, even if federal courts could afford immunity to tribes as a matter of comity considerations would not help petitioners. Even with respect to fully sovereign foreign nations, comity has long been discarded as a sufficient reason to grant immunity for commercial acts like those at issue here. And, far from furthering comity principles, recognizing immunity for off-reservation commercial acts represents a substantial affront to a different set of sovereigns, the states. When a tribe engages in off-reservation commercial activity, it necessarily acts within the territory of a sovereign state. Thus, grant tribes a unique and unjustified immunity from both federal and state jurisdiction for commercial acts committed on a state's territory aggravates relationships between states and tribes throughout the country. Accordingly, any common law immunity that petitioners possess cannot support their claim to immunity in federal court for their off-reservation commercial conduct. The court's tribal immunity doctrine is also out of step with more recent decisions. In Franchise Tax BD of Cal v. Hyatt, the court recognized that the 50 states possess a unique form of immunity that applies of its own force in the courts of sister states, as well as those of the federal government. This immunity stems from the Constitution itself, and belongs only to the 50 states through their ratification of the Constitution, or admission to the Union on an equal footing with the original states. As a result, it is distinct from common law immunity, which depends upon the forum court's sovereign for recognition. By treating tribal immunity like state immunity, the court's tribal immunity case law has afforded tribes, by judicial fiat, a form of immunity that the Constitution accords to the 50 states, and only the 50 states. Finally, this court's tribal immunity doctrine continues to artificially exempt tribes from generally applicable laws. I warned nearly a decade ago that tribal immunity will continue to invite problems, including de facto deregulation of highly regulated activities, unfairness to tort victims, and increasingly fractious relations with states and individuals alike. This is a case in point. In order to avoid state payday loan regulation, payday lenders often arrange to share fees or profits with tribes so they can use tribal immunity as a shield for conduct of questionable legality. Petitioners here rely on tribal immunity to avoid not only state but also federal payday loan regulation. They further seek to leverage this immunity to pursue respondent on his debt, while other creditors' collection efforts are stayed. Tribal immunity thus creates a pathway to circumvent vast swaths of both state and federal laws. The consequences of the court's erroneous tribal immunity precedents have only gotten worse over the years. Further, the doctrine simply cannot be reconciled with the court's precedents affirming that the states have legislative jurisdiction over the off-reservation conduct of Indian tribes, and even over some on-reservation activities. Rather than accepting the flawed premise of tribal immunity and deciding the abrogation question beyond the looking glass, the court should simply abandon its judicially created tribal sovereign immunity doctrine. Justice Gorsuch, dissenting. Until today, there was not one example in all of history where this court had found that Congress intended to abrogate tribal sovereign immunity without expressly mentioning Indian tribes somewhere in the statute. No longer. The court reads the phrase other foreign or domestic government, 11 U.S.C. section 101(27), as synonymous with any and every government, all for the purpose of holding that section 106A of the Bankruptcy Code abrogates tribal sovereign immunity. It is a plausible interpretation, but plausible is not the standard our tribal immunity jurisprudence demands. Before holding that Congress has vitiated tribal immunity, the legislature must unequivocally express its intent to achieve that result. Respectfully, I do not think the language here does the trick. The phrase other foreign or domestic government could mean what the court suggests, every government, everywhere. But it could also mean what it says, every other foreign government, every other domestic government. And properly understood, tribes are neither of those things. Instead, the Constitution's text, and 2 centuries of history and precedent, establish that tribes enjoy a unique status in our law. Because this reading of the statute is itself, at worst, a plausible one, I would hold that the Bankruptcy Code flunks this court's clear statement rule in reverse. As the court reaffirms today, the doctrine of tribal immunity is settled law. Nor should that fact come as a surprise. From the founding to the present, this court has recognized the tribe's continued existence as independent sovereigns. A necessary corollary to that Indian sovereignty is immunity from private suit. It is, after all, inherent in the nature of sovereignty not to be amenable to the suit of an individual without its consent. That understanding, derived from both common law sovereign immunity and law of nations sovereign immunity, is a background principle on which the Constitution itself rests, and it applies to tribes no less than foreign nations, a tradition that traces back over 170 years. While venerable, tribal immunity, like its state and foreign counterparts, is not immutable. The federal government can abrogate it, at least as far as its fonts of power let it. But the choice to abrogate tribal immunity is fundamentally political in nature. It is a choice that therefore belongs to Congress, the department which can modify the law at will, and not the judiciary, the department which can pursue only the law as it is written. Recognizing the Constitution's division of responsibility, this court has long left all decisions about tribal and other sorts of sovereign immunity in Congress's hands. Because erroneous abrogations of immunity risk inter-sovereign conflicts and reprisals, this court employs an additional interpretive guardrail, a clear statement requirement designed to ensure that the political branches acted knowingly and intentionally in divesting sovereigns of their legal entitlements. Under this approach, we will not read a statute to abrogate immunity if any other possible construction remains. That goes for tribes. Just as it goes for other sovereigns, it is an enduring principle of Indian law that we will not lightly assume that Congress in fact intends to undermine Indian sovereignty, absent pellucid evidence to the contrary. All this explains the now familiar clear statement rule that this court has endorsed on countless occasions. If Congress wishes to abrogate tribal immunity, its decision must be clear, and the legislature must unequivocally express its decision in the text of a statute. Under that rule, any ambiguities in the statutory language are to be construed in favor of immunity. Keep that hard-to-meet standard in mind. We will return to it as we make our way through the statutory text driving today's dispute. The Bankruptcy Code stipulates that, notwithstanding an assertion of sovereign immunity is abrogated as to a governmental unit to the extent set forth in this section. That language, this court has previously held, signals a clear intent to abrogate sovereign immunity. But as to which sovereigns? The answer to that question lies elsewhere in the Bankruptcy Code. The term governmental unit, it says, means United States, state, Commonwealth, district, territory, municipality, foreign state, department, agency or instrumentality of the United States, but not a United States trustee while serving as a trustee in a case under this title, a state, a commonwealth, a district, a territory, a municipality, or a foreign state, or other foreign or domestic government. That is a lot of words. For present purposes, however, only the last 5 matter. Other foreign or domestic government. No one argues any of the other clauses could potentially refer to tribes. We can further winnow down the options from there. No one thinks tribes qualify as foreign governments. That leaves only 2 possibilities. Tribes could qualify as domestic governments' respondents' lead argument, or the phrase other foreign or domestic government, read as a whole, could mean any and every government respondent's backup argument and the one the court adopts today. Neither possibility is the slam dunk our familiar clear statement rule requires. Consider each in turn. Start with the domestic government possibility. At the time Congress adopted the provisions of the Bankruptcy Code at issue before us, the word domestic carried only 2 potentially relevant meanings. It could mean spatially domestic, i.e., within the territorial confines of the United States, or it could mean politically domestic, i.e., a subpart of the United States. Contemporary definitions support each of those possibilities and only those possibilities. If we were to read the term only in its spatial sense, as the First Circuit did below and respondent urges us to do, it makes some sense to speak of tribes as domestic. These days, tribal jurisdiction usually falls within the United States territorial bounds, although that was not true for most of the nation's history, and became so only after the West was won. Of course, usually does not mean always. Even to this day, all 3 branches of government struggle to address the status of tribes that straddle our nation's borders. Evidently, our neighbor to the north has encountered similar difficulties. Focusing only on the spatial meaning of domestic, however, would miss an obvious point. When it comes to the status of governments, this court has long recognized that geography takes a back seat. Whether a government qualifies as domestic instead usually depends on the political relation in which one government or country stands to another. The term has no relation to local, geographical, or territorial position. At minimum, this line of thinking leaves open a reasonable possibility that Congress in Section 10127 meant the term domestic in its political, not geographic sense. Accordingly, for respondent's primary argument to succeed, he must show that the political relationship between Indian tribes and the United States is such that the term domestic government clearly covers them. That is a burden respondent cannot carry. Properly understood, Indian tribes occupy a unique status that is neither politically foreign nor domestic. Significant evidence supports this understanding. Start with the text of the Constitution. Its terms appear to place Indian tribes in an intermediate category between foreign and domestic states. At least 2 provisions illustrate as much. One is the Commerce Clause, which gives Congress the power to regulate commerce with foreign nations, among the several states, and with the Indian tribes. The inclusion of that 3rd Commerce Clause power suggests that tribes were not reachable either by Congress's foreign commerce power, or by its domestic, interstate commerce power. More obscure but no less probative, is the Constitution's exemption from the apportionment formula of all Indians not taxed. That choice recognizes that tribes are not fully domestic to the United States, and instead stand separate from the polity. These provisions too reflected a widely shared understanding about the sovereign status of tribes at the founding. As Secretary of War Henry Knox put it in a letter to President Washington, the tribes were in many ways akin to foreign nations and not part of any particular state. Consistent with this understanding, before 1871 the United States, and prior to that, Great Britain, chiefly managed tribal relations by way of treaty. Entering into those treaties admitted that the tribes rank among those powers who are capable of making treaties. Governments do not normally deal with politically domestic authorities in that manner. This court's earliest Indian law jurisprudence offers more evidence along the same lines. In Cherokee Nation v. Georgia, 3 distinct views of tribal sovereignty emerged on the question whether, for purposes of Article 3, the Cherokee Nation was a foreign nation. In the lead opinion for the court, Chief Justice Marshall emphasized that the condition of the Indians in relation to the United States is perhaps unlike that of any other 2 people in existence. For the limited purposes of Article 3, Chief Justice Marshall rejected the view that the tribes could, with strict accuracy, be denominated foreign nations. Instead, he suggested, they may, more correctly perhaps, be denominated domestic dependent nations. But notably, he did not describe the tribes as domestic for all purposes. To the contrary, he deliberately chose the term nations, stressing also that in the general, nations not owing a common allegiance are foreign to each other. In that way, he said, the relation of the Indians to the United States is marked by peculiar and cardinal distinctions which exist nowhere else. Read in context, the term domestic dependent nations is really a term of art meant to capture tribes' hybrid position between foreign and domestic states. The remaining opinions in Cherokee Nation underscore this message. Justice Johnson, concurring, rejected the moniker foreign state, but he also thought it very clear that the Constitution neither speaks of tribes as states or foreign states, but as just what they were, Indian tribes, an anomaly unknown to the books. Justice Baldwin, also concurring, rejected the idea that tribes were states, foreign or domestic. And Justice Thompson, joined by Justice Story, dissented on the grounds that he thought the Cherokee had a chiefly foreign character, all things considered. All told, this court split sharply as to the best way to characterize the legal status of tribes in relation to the United States. But if there is one thing all members of the court could have agreed on, perhaps it would be this: neither the term foreign government nor the term domestic government adequately captures the tribe's unique legal and political status. This court's later decisions only give further reason to doubt that tribes are clearly domestic governments. No less than this court's first case analyzing tribal sovereign immunity rested on the view that each tribe remains in many respects, but not all, a foreign and independent nation. That language not only weighs against treating tribes as domestic governments, it does so in precisely the context at issue here: sovereign immunity. If we can assume that Congress is aware of this court's relevant precedents, the notion that the Bankruptcy Code abrogates tribal sovereign immunity is sunk. That seems like an especially safe assumption here, given that Congress adopted its most recent version of the provision after this court, twice, held that the provision failed our clear statement rule as to other sovereigns. That the respondent in this case nowhere discussed parks in his briefing, and had nothing to say about it at argument, speaks volumes. Of course, respondent has bigger problems than just the words this court has used. He must contend with the reality of this court's Indian law jurisprudence, which in practice has consistently treated tribes as a constitutional hybrid, resembling states in certain respects and foreign nations in others. For example, while Congress has certain legislative authority over tribal lands, the tribes themselves need not abide by the Bill of Rights or the 14th Amendment. Instead, they are governed by unique regimes of civil and criminal jurisdiction, involving overlapping federal, tribal, and state authorities unlike those employed anywhere else, and their unique character makes their brand of sovereign immunity not congruent with the immunity other sovereigns enjoy. Nor are tribes alone in standing outside the foreign/domestic dichotomy. Take the court's treatment of the so-called insular territories. It depends entirely on the idea that those territories are neither foreign nor domestic, but instead, unique entities foreign to the United States, in a domestic sense. No one could accuse me of having fondness for the insular cases, but their existence is fatal for respondents' theory. After all, the insular territories are a close comparator to tribes, and many have considered both tribes and territories to share the same status as foreign to the United States, in a domestic sense. Tellingly, too, Congress expressly abrogated any immunity territories may enjoy under the Bankruptcy Code. Yet it did no such thing when it came to the tribes. Respondent has no real answer to any of this. He cites some cases in which this court reprised the domestic dependent nations language from Cherokee Nation. But as we have seen, that language actually stands for a view of tribes flatly inconsistent with the domestic government characterization. Taking away those examples leaves respondent with thin gruel. He directs us to United States v. Cox, but that case observed only that Cherokee territory counts as domestic territory. The decision thus plainly used the term domestic only in its spatial sense. The same goes for Blatchford v. Native Village of Noatak. There, this court recognized that tribes are only in some respects more like states than foreign sovereigns. Read with this context in mind, its statement that they are, for example, domestic, referred only to their spatial location. Confirming this point, the rest of the paragraph contrasted the tribe's physical domesticity with features of their political relationship with the United States. More fundamentally, even granting respondent these examples would not do him any good. Just think of the balancing task we would face. On one side of the scale, we would have a couple of scattered quotes, cherry-picked from over 2 centuries of Indian law jurisprudence, bandying about the word domestic when describing certain features of tribes. On the other side of the scale, we would have the text and history of the Constitution, supported by more and better examples of this court's jurisprudence fashioning rules of law treating tribes as sui generis. Faced with all that countervailing authority, the best respondent could realistically hope for is that we declare Section 101(27) a jump ball, and under our clear statement rule, a jump ball is as good as a possession arrow favoring the party opposing the abrogation of sovereign immunity. Taking the domestic government possibility off the table leaves only one other. Respondent falls back on the idea that foreign or domestic is really just shorthand for every government under the sun. The court relies solely on this reading, holding that Section 102(27) unequivocally abrogates the sovereign immunity of any and every government that possesses the power to assert such immunity. Getting to that conclusion from the statutory text requires 2 interpretive moves. First, the reader must treat the words foreign or domestic as a single, undifferentiated clause, rather than as a disjunctive grouping of descriptors. Second, the reader must take that undifferentiated clause to mean anywhere and everywhere. Each move is plausible, neither is clear, and a problem with either is game over. Start with the first move. Respondent would have us read foreign or domestic as a unitary clause expressing a single, shared idea. This is what linguists might call a hendiatus, 2 terms separated by a conjunction that work together as a single complex expression. On occasion, English employs that sort of construct, but those occasions are the exceptions, not the rule. Nor is it clear that is what we have here, as even respondent concedes, or in its ordinary use instead indicates that the words it connects are to be given separate meanings. A perfectly natural reading then would ask whether tribes clearly qualify as foreign governments or as domestic governments. And because the answer is no on both scores, for the reasons already laid out above, the language flunks the clear statement rule. The second move has issues too. The case for treating foreign or domestic government as synonymous with any government anywhere rests on the premise that the terms are 2 extremes, so that by invoking both, Congress meant to cover every part of an all-inclusive spectrum. The court analogizes to the phrase near and far, which it argues sometimes means all over the map. But the premise here is faulty and the analogy inapt. Near and far may well be 2 extremes. One would not speak of a location being both near and far at the same time, for example. When it comes to sovereigns, however, the terms foreign and domestic do not share that same quality. Rather, as we have seen, an extensive tradition supports treating certain sovereigns, tribes among them, as sui generis entities falling outside the foreign/domestic dichotomy. That tradition is fatal under the clear statement rule. How does respondent contend with this problem? At argument, he retreated from his briefing and relied instead on a provision of the Bankruptcy Code stating that, for purposes of that code, or is not exclusive. From this, respondent reasoned, the Bankruptcy Code abrogates tribal immunity because everyone can agree at least that tribes bear some qualities of both foreign and domestic governments. The provision respondent cites simply does not do what he seems to think it does. In common usage, the term or can carry 2 meanings. The first is exclusive. It requires full satisfaction of one and exactly one listed condition. The second is inclusive. It requires full satisfaction of at least one listed condition. All Section 102(5) does is favor the latter meaning for purposes of the Bankruptcy Code. Sound complicated? Just look at an example. Suppose you tell your child that he can get a pet so long as it is small or a dog. The child can choose a small animal, like a hamster, or a large dog, like a mastiff. But can the child also choose a small dog? If the or is inclusive, as respondent argues it is here, the answer is yes. If it is exclusive, the answer is no. Critically, however, neither reading covers a medium-sized aardvark. Such an animal may be somewhat small and somewhat dog-like, but 2 near misses do not add up to a hit. This is a simple point but an important one. Regardless of whether or is used inclusively or exclusively, one of the input conditions must be satisfied. With this point in mind, respondent's reading collapses. To see why, consider another example. Suppose you are a house guest, and your host invites you to help yourself to the chocolate or vanilla ice cream in the freezer. Upon opening the freezer, you find 3 tubs: vanilla, chocolate, and Neapolitan. For argument's sake, too, let's say the last tub also has a sticky note. Do not eat without clear permission. Which ice cream can you take? If the host meant or exclusively, you may take either chocolate or vanilla, not both. If the host meant it inclusively, you may scoop some of each. In neither event, however, would you have permission to take the Neapolitan ice cream, especially given the cautionary note. As a unique composite, it does not clearly satisfy either of the necessary conditions. So too here. Tribes may have some features of both domestic and foreign governments, but they do not clearly qualify as either, and they have some features found in neither. Accordingly, Section 102(5) does nothing to rescue respondent's cause. If anything, Section 1025 only sheds light on what the catch-all term other foreign or domestic government does cover. That phrase sweeps up, as Chief Judge Barron explained in dissent below, certain otherwise excluded, half-fish, half-fowl governmental entities like authorities or commissions that are created through interstate compacts, other domestic governments, and the joint products of international agreements, other foreign governments. Without the catch-all, entities of these sorts could potentially fall through the cracks. Tribes, by contrast, are among the most significant entities wielding sovereign immunity. They are a unique form of government, and they alone are nowhere mentioned. The court offers two responses. Above the line, it asks why territories are encompassed within Section 101(27)(z) immunity abrogation provision if they share the same status of tribes, neither foreign nor domestic. The answer, of course, is that Congress expressly listed territories. It did not do the same for tribes. Nor do I see how Congress's choice to include territories supports the court's suggestion that the term other foreign or domestic government clearly covers all governments. To the contrary, under the court's interpretation of that term, the express inclusion of territories becomes curious surplusage, and to the extent the court thinks Congress mentioned territories just to be doubly clear that the term other foreign or domestic government really does cover all governments, adopting a kind of belt and suspenders approach, isn't it odd that Congress left one of the most notable types of sovereigns, a key part of its belt, at home? Below the line, the court simply asserts without analysis or support that the terms foreign and domestic are two poles on a spectrum. It does not grapple, however, with the many decisions of this court discussed above that contradict that premise, and that do so in the precise context of Indian law in general and sovereign immunity in particular. Nor does it grapple with the reality that, even if the terms were two poles on a spectrum, many justices of this court have suggested that Indian tribes do not fall along that continuum at all, and are instead just what they are, Indian tribes. Others, of course, have disagreed, but that disagreement is no help to the court under our clear statement rule. It is dispositive the other way. Unable to demonstrate that the statute's terms clearly abrogate tribal immunity, respondent and the court stress that Section 101(27) as a whole exudes comprehensiveness. That is obviously true but not obviously helpful. Really, the express inclusion of so many other types of sovereigns in the Bankruptcy Code's abrogation provision only deepens the mystery, why tribes are nowhere mentioned. Normally, after all, when Congress includes so many items within an associated group, we assume the omission of another means that it has been deliberately excluded. Nor, for that matter, has this court ever held that a statute's general atmospherics can satisfy the clear statement rule when the text itself comes up short. The court also invokes the Bankruptcy Code's purposes. It contends that Congress designed the code in part to offer debtors a fresh start, that its provisions were intended to sweep broadly, and that petitioners' view of the statute could upend the policy choices that the code embodies. In a similar vein, the court wonders what reason Congress possibly could have had for excluding tribes from its abrogation provision. These are fair questions and concerns. Some of them I share, but they too have no place in a case like this one. For purposes of satisfying a clear statement rule, attempts to construe Section 106 in light of the policies underlying the Bankruptcy Code are unavailing. Perhaps members of Congress had good reasons for failing to include tribes in Section 101(27). Perhaps their decision reflected a measured political compromise, or perhaps the issue of tribal immunity simply never came up. In all events, the result is the same. Absent some clear textual indication, there can be no abrogation. Setting aside those policy concerns leaves the court with a methodological one. It fears adopting my approach could transmute our clear statement rule into some sort of magic words test. I do not see how it could. Congress could identify tribes in any number of unmistakable ways: Indians, Native Americans, indigenous peoples, or even, as we have seen, domestic dependent nations. Congress has had no trouble using language like that in plenty of other statutory contexts. Alternatively, Congress could identify tribes by description, for instance, any other government that operates in whole or in part within the territorial bounds of the United States. Alternatively still, Congress could abrogate all sovereign immunity through some unequivocal statement to that effect, using, for example, the court's own formulation, any and every government. The only thing Congress cannot do is use oblique or elliptical language to supply a clear statement, because that is, at best, what the Bankruptcy Code provides. I respectfully dissent. Thanks for listening. This podcast is not affiliated with the United States Supreme Court or its staff in any way. The summary of this opinion given in the introduction was taken from the summary provided at oyez.org. Any mistakes in the opinion you just heard should be attributed to this podcast. If you would like to support my efforts to make Supreme Court opinions available to the public, please subscribe. Thank you.